Mr. Kadela, and then we'll finish up with Professor Bronfenbrenner.
Chairman Liebman, members of the board, good afternoon. My name is David Kadela. I'm a shareholder in the Columbus, Ohio office of Littler Mendelson. And it's my privilege to appear before you today on behalf of the firm to share with you our views on the proposed amendments. With over 800 attorneys, Littler is the largest firm in the country representing management exclusively in labor and employment matters. We have represented countless clients from Fortune 100 companies to family-owned enterprises in representation matters in every region of the board. Today, I cannot capture in my comments the views of all of my colleagues regarding these proposed changes. Collectively, however, we do share the view that the changes would first unduly and severely cut into the time that employers have to communicate with employees during an election campaign when their right to do that is at its greatest and most important. And secondly, that it would establish unnecessary procedural requirements that would stack the deck against and increase the burdens upon employers. We believe that in the main, the proposed changes are unnecessary and would have so sweeping an effect on the processing of elections that if they are to be considered, it should only be by Congress, like the Employee Free Choice Act, and going back much further, like the Labor Reform Act of 1977, which also included a provision that did not get through Congress, of course, providing for quickie elections. With this background, I'd like to turn now to some of the specific concerns, and given that my time is brief, I realize I may not get through all of them, so I'm going to start with the expedited election process. It's been reported that the proposed changes would result in elections between 10 and 21 days compared to the 38-day median that exists today. You all have heard many on the union side champion that change, arguing that the actions necessary to curb the opportunities that employers have to coerce and intimidate employees in election campaigns. The facts, at least in my experience, my colleagues' experience, and I think virtually everyone you've heard from here on the management side, don't bear that argument out. I'm sure that that dispute is not going to be resolved during the course of these proceedings, but I would submit to you that the reality is that unions can only pin a very small number of their losses and can only pin the delay upon the conduct of very few employers. In our experience, the vast majority of employers are vigilant and steadfast in complying with the law during organizing drives. Do some individual supervisors slip up and commit minor violations? That happens from time to time. But primarily, my experience is that employers are vigilant in complying with the law and that their focus is on communicating accurate, factual information to employees on what union representation would mean. In our view, the communication of that measure in large measure explains the poor showing by unions in organizing new workers. As we see it, it's no wonder that the union side would throw their support behind changes that would serve to muzzle employers' exercise of their rights under Section 8C. The board, however, has an obligation to ensure that those rights are protected. In its notice, the board said that the purpose of the proposed changes was to streamline and modernize representation procedures to foster the objective of resolving questions of representation quickly, fairly, and accurately. That's a laudatory goal, but the changes, in fact, really only go to the speed of the process. While promoting speed, they would undermine employer free speech rights and put at risk the fairness and accuracy of elections. The Act mandates that the perceived need for speed must yield to these other considerations. Fairness and accuracy are of paramount importance. Individually and collectively, they trump speed as a factor. To ensure that they are conducted fairly and that they accurately reflect employee sentiment, elections necessarily cannot be timed so that employees mainly, if not exclusively, hear only the union's message. Again, the debate between are employers bad actors and are they responsible for intimidating, cursing employees? Is that a cause of the poor showing by unions? You know, is that the issue, or is the experience, as others have said, that employers typically do not learn about a campaign until the election petition is filed? You've heard totally different polar views on all of these subjects during the course of this proceeding that we don't think that you'll be able to resolve. But there are certain things that you can say, and then if Section 8C is interpreted as the Supreme Court has said Congress intended, employers must be afforded ample time to communicate their views on unionization to their employees. 10 to 21 days doesn't cut it. Denial of a fair opportunity to exercise a right is the denial of the right. On this particular topic, I'd like to address one other thing too. It has been said, but it hasn't necessarily, it's been linked to Section 7, but not otherwise, that employees must be afforded sufficient time to consider the views of both management and labor and to study the issues on their own before they vote. Besides Section 7, that right can be gleaned from Section 1 of the Act, which provides that a central purpose of the Act, really one of two, is to protect the exercise by workers of full freedom of association, self-organization, and designation of representatives of their own choosing. Full freedom means freedom to consider all views and opinions. The current system provides employees with such freedom. If the amount of time employees have to consider information is cut by as much as or more than half, as the proposed amendments would do, it will create a very real risk that when employees enter the voting booth, they will not have been provided with all of the information they need to cast an informed ballot. Speed for the sake of speed doesn't warrant taking that risk. I see the red light is flashing already, but
Well, let me see if my colleagues have any questions.
I do. I know that you've been involved with the American Bar Association, with the Bar Association's Practice and Procedure Committee. My question is that when the board typically contemplates changing even minor rules or regulations for practitioners before the board, isn't that typically something that is discussed with the Practice and Procedure Committee before the rule changes are proposed?
there have been occasions where there have been initiatives that have been presented to us as a committee. Then we as a committee meet internally, and the way those issues come out of our committee would only be if the management side and the union side reached a consensus. And then in that event, we would report our consensus view to the board. Otherwise, certainly individual members of the committee are free to express their own views to the board.
Is this proposal one that perhaps would have benefited from a referral to your committee to at least elicit the views of your members before a rule was proposed?
I certainly think that it would have. Given the divergent views that we've heard on this subject, it's a virtual certainty that we would not have reached a consensus. But it may well have resulted in our members forming views and information that individually they could have shared with the board by providing comment.
And just finally, wouldn't the activity of soliciting the views of labor and management practitioners in that forum have been in accord with President Obama's executive order with respect to rulemaking by both federal agencies and independent boards?
Whether or not it would have complied with the letter, it certainly would have complied with the spirit.
Thank you.
I wanted to follow up. I actually was going to ask some similar questions, particularly because of your comment about, I think you used the phrase polar views. I think it's been obvious to most of us here the last few days that wide divergence of viewpoints. And I know it's been suggested that we should have conferred more, say, with the Practice and Procedure Committee. And you just said you think the likelihood of having reached consensus wasn't great. But let me ask you another question. Do you know whether, had we conferred with you on this, we would have been in violation of the Federal Advisory Committee Act?
I do not know the answer to that offhand.
Yeah. I mean, because I think we would have. That's number one.
But
on
it
many
should-
occasions, issues are brought to you. For example, I think the possibility of electronic voting. There was a presentation and a lively discussion of that. Is that not correct?
No question about it. But I would say with respect to the advisory committee issue, our committee is not an advisory committee. And so that would have, the presentation to them would have presented us with the first challenge we would have met in a meeting had we been presented with these proposed changes, would have been to say whether we can touch them as a committee because we would be serving in an advisory capacity. It may be very likely that we would have never gotten past that hurdle. That said, we certainly as a committee appreciate it on every occasion that the board comes to us with information and solicits our views. Whether or not we can move forward and provide the feedback for which the board is looking is another matter. It's a very helpful process nonetheless.
We did have a discussion at one of the meetings about Professor Estreicher's article and his suggestion for reforming the election process and other suggestions, didn't we? We had a
Yes.
long, quite lively discussion of his proposals, am I not correct?
That is true.
So in fact, we have on numerous occasions come and discussed issues that are relevant to this proposal. Isn't that right?
Well, I would say that the context in which the issues have been discussed will vary from a presentation by a speaker that is known to be that speaker's own views when people go back and forth knowing that our objective is not to reach a consensus on an issue or provide advice on an issue, but to get the issues on the table and express our views and have a free exchange. To what end, it's difficult to say, but it's no different than any other type of seminar situation in my view.
I guess my point is that we may not have been presented as this is the board's proposal to change its rules, but many of the substantive areas have been discussed quite freely at a variety of practice and procedure committee meetings.
That is very
That's
true.
correct. Thank you. Anything else?
Well, thank you very
Thank you
much
for
again. I
coming
appreciate the
and
opportunity.
giving us your input. And